Executor and Administration Guide, page 34. Fund is safe is his hands, to be administered as directed. Courtwell versus Brook, Brand 148. This complaint should undoubtedly be on oath, stated the case of a complaint clearly and explicitly, and thereupon the surrogate will issue a summons to be personally served at least 6 days before the return day, if the executor be in the county, or if he shall have absconded from the county, it may be served by leaving it at his place of residence. If on the return day the summons shall appear to have been duly served, and on hearing the proofs of the allegations of the parties, it shall appear that the complaint is sustained, the surrogate shall require the executor to give a bond with sureties like those required of administrators within note exceeding 5 days. The cost of the application, if granted, should, as a general rule, be charged on the fund that is the estate. Holmes versus Clark, Second Bar, Channel 426, Chapter 426. If such person elect to give a bond, if it appear that he is legally incompetent, the surrogate shall by orders supersede the letters testamentary so issued to him, and his rights and authority as executor shall thereupon cease if after such removal there be no acting executor of such will. The surrogate shall grant letters of administration with the will annexed in the manner above set forth. 35. And in all cases, the administrators with the will annexed shall observe and perform the will, and their rights, powers, and duties shall be the same as if they had been named executors in the will. 2R.S.72, 3R.S.5th 157. But he cannot sell or dispose of the real estate for the purpose of the division among legatees, or do any act about the real estate without further authority from the Supreme Court. Coughlin versus Egerton 21, WN.430. Affirm on another ground, 25 win, 2224, Dominique versus Michael, 4 Sand.SUP, CTR 37, Wounds versus Phillips, 27, New York, 357. But if the administrator with the will annex assumed to act as a trustee as to the real estate in place of the executor appointed and who declined to act, those interests might consider him as trustee instead as a wrongdoer, and have him removed for neglect of the duties proper to the trustee. Second EWEDW chapter 32. And it being doubtful whether the administrator with the will annex was authorized to execute and trust power given to the executor name. And 36. When a person dies leaving no will, he is said to die intestate, and letters of administration are granted on his estate. Administrators in their respective capacity have no charge over the real estate of their intestate. Administrators in their representative captivity have no charge over the real estate of their intestate. Hillman versus Stefan, 16 New York 278. Griffin versus Betcher, 10 bar 432. And their authority is local, extending only as the asset within the state. Doolittle versus Lewis, 7 John, chapter 45. There are 3 forms of letters of administration: general letters upon the estate of the interstate, special letters of collection upon the interstate of either an interstate or testator in certain cases, and letters of administration with the will annex. 23 R.S.73, 3R.S.5th edition 158. The circuit of each county shall have sole and exclusive power within the county for which he may be appointed to grant letters to the administration of the goods, chattel, credits, persons dying interstate in the following cases, where an interstate at immediately previous to his death was an inhabitant of the county of such surrogate in whatever place such death may have happened, where an interstate not being an inhabitant of this state shall die in the county of such surrogate, leaving assets, that is, personal property or evidence of debt therein, where the interstate not being an inhabitant of the state shall die out of the state, leaving assets in the county as such surrogate and is no other county, where an interstate not being an inhabitant of the state shall die out of the state, not leaving the assets therein, but assets of such interstate shall thereafter come into the county of such surrogate. The person applying for general letters of administration must produce proof to the satisfaction of the surrogate that the deceased left no will of time, place, and manner of his death, and the value of his personal estate. If it is alleged in opposition to the application for the letters of administration that there is a will and the will is traced last to be the possession of the deceased, there must be proof of the search among his papers. And if it be not found, presumption will be that it revoked it by destroying it. Berkeley versus Redmond, Second Brand 281. Surrogate must examine the persons applying and may also examine other persons and compel their attendance. Usually, however, this proof is all included in the petition, which is presented for letters by the applicant. The petition must also state whether the deceased left a widow with her name and the name and place of the resident of the next of kin, or that these facts cannot, after diligent inquiry, be ascertained, and what relations the petitioner has to the estate. See Form Appendix 27R.S.74 of the 58 amended. Chapter 782 Laws of 1867 Administration in case of intestacy shall be granted to the relatives of the deceased who will be entitled to succeed to his personal estate if they are of any of them will accept. The same in the following order: first to the widow, second to the children, third to the father, fourth to the mother, the brother, the sixth to the sister, seventh to the grandchildren, eighth to any other next in kin who will be entitled to share of the distribution of the estate, if any of the person in so title be minors. Administration shall be granted to their guardians. If none of the said relatives or guardians will accept the same, then the creditors of the deceased and the first creditors applying will, if otherwise competent, be entitled to their preference. Where a person dies leaving a father and a brother, it is error to grant letter to the creditor. Upon the recognition of the fathers only, Luther versus Smith, 35 Bob 64 and 24 New York 417. If no creditors apply, then to any other person, the person legally competent, but in the city of New York, the public administrator shall have preference after the next of kin over creditors and all other persons. And the other counties, the county treasury shall have preference. Next after creditors over all other persons. And in the case of married woman dying interstate, the husband shall be entitled to administration in preference to all persons. This section shall not be construed to authorize the granting of letters to any relatives not entitled to succeed to the personal estate of the deceased as his next of kin at the time of his decease, where several persons of the same degree of the kindred apply for letters. Males are preferred to the females, relatives of the whole blood to those of the half-blood unmarried woman to such as married, and where several persons in the same degree or equal in title apply to the surrogate may appoint such as in discretion and he thinks most fit. 29 2R.S.75 3 R.S.5th 159, and husband as such, if otherwise competent according to law, shall be solely entitled to administration on the estate of his wife, and shall give bond as other. Okay.